Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. This is a case decision and we're only going to look at it from the FDCPA standpoint, Fair Debt Collection Practices Act. And specifically, if you notify a debt collector that you disputed debt, how must that be reported to the credit bureaus if that debt collector updates your report? And we'll see there's a little bit of conflict here between what the debt collector says and what the credit reports say, or consumer disclosures if we want to be kind of technical with what we're talking about. So part of this opinion we'll skip over because it's not related to the dispute part. And I'll mention this at the end of the video as well. But if you look in the description or the first comment, you'll see a link to go to a webinar we're doing completely free. It's a masterclass on dispute letters to debt collectors. And we're having that this Thursday at 11 a.m. Central Time. And so you're certainly welcome to join us for that. So let's look at this case against National Credit Systems. And this is from April of 2021. This is Judge Mays in Northern District of Alabama. So it all relates to the consumer moving out of an apartment and the apartment saying, you owe us $734. And the consumer's arguing about that. And ultimately, the consumer told the debt collector, I dispute this debt, but then the debt collector did not communicate that to the credit bureaus or the credit reporting agencies. Those are places, Equifax, Experian, TransUnion. And so the allegation is that violates Section E8 of the FDCPA. So we'll look just briefly at the facts because they're not particularly important for us. But this is a very typical situation where there's an argument between the apartment complex and the consumer about, did you move out with the proper notice? Was there damage to the apartment? What about the security deposit? All that type of stuff. And so we see here that the village charged him $734. Okay. And so then they hired this debt collector, NCS, and this is all the way back in October, where October 2017, debt collector writes to the consumer saying, hey, we want payment. Consumer writes back and says, we don't owe you any money. And then there's continued disputes for a couple years. Well, then in October of 2019, Andrew obtained his credit reports. And so let me just say this. I'm going to call them credit reports through this. For those that might be more technical, when we obtain our own reports, those are called consumer disclosures. But in sort of the normal world, like Judge Mays is doing here, we just call them credit reports. So pulled his credit reports. You can do that for free once a week now through annualcreditreport.com. And so that has the debt by this debt collector, and then in 2020 writes to Experian disputing the debt, and then NCS receives the dispute. 10 days later launches an investigation. They reach out to the apartment complex, say, hey, he still owes us money. So the debt collector verifies the debt, but it claims that it told the bureaus, the CRAs, that the consumer disputed the debt. But then when the consumer gets his credit reports, there's no notation that the debt's disputed. So this is an interesting situation that we run into where you sue the debt collector for failing to note your account as disputed, and they say, we did tell the credit bureaus it was disputed. Well, how do we figure that out? Well, there's a couple ways. One, we can subpoena all the communications between the debt collector and the credit bureau. Now, we can force the debt collector to give that to us because they're in the lawsuit. But the credit bureaus, if they're not in the lawsuit, then we go subpoena the information. And I'm not sure exactly what happened here, but we'll see how the judge handles it. And so there's a part about standing. We've talked about that. Standing is, do you have the right for the doors of the federal courthouse to open? Mainly, do you have an injury? We're not going to focus in on that. And then let's really zero in on this count 5 or part 2 of the opinion, the FDCPA. And so here's what the court says. The only thing that's left is alleged violation of 15 U.S.C. section 1692E8. So that prohibits debt collectors from, quote, communicating or threatening to communicate to any person, and that would include a credit bureau, any person credit information which is known or should be known to be false. Now, if it just stopped there, then the debt collectors would have an argument that we have to prove that the information is wrong. But it doesn't stop there. The sentence continues by giving us an example, including the failure to communicate that a debt is disputed. And then Judge Mays goes on to say, let me just highlight down to here. The 11th Circuit has yet to address when a debt collector's communication with CRAs violates this provision, but at least 3 other courts of appeal have held that debt collectors violate section 1692E8 when they elect to communicate with the bureaus about an alleged debt but omit that the debtor disputes the debt. So we've got the 7th Circuit, we've got the 8th Circuit, and then there's also the sales case. And so why do they do that? Well, there's a couple reasons. First, nothing in the text of 1692E8 requires the consumer's dispute to be valid or reasonable. Okay? So this is different than the Fair Credit Reporting Act in as far as the requirement there to mark an account as being, quote, disputed. And then second, the failure to inform a credit bureau that the debtor disputed his or her debt will always have an influence on the debtor or the consumer, as this information will be used to determine the consumer's credit score. So almost all the scoring models will either minimize the negative effect of a disputed debt collection account or will just skip over it completely. So they ignore any debt collection account that's marked as disputed. Well, the reason that these debt collectors report it is only one reason. That is to hurt you as a consumer, to motivate you, or as one court said, to sort of wrench a payment out of you. That's why they do it. Now, they'll talk in terms of, we have an obligation to our fellow companies out there who are in the credit. No, that's garbage. They only do it to hurt you, because if they can inflict enough pain on you through dropping your credit score, then you'll be more motivated to pay them. That's how this process works. And so they have to mark it as disputed, even if they say, well, you didn't give us a good reason. Actually, you don't have to give them any reason. And in our class on Thursday, and I have a bunch of videos on this as well, right now on YouTube, you can just simply say, I dispute any debt that you claim to have on me. You don't have to give any reasons, okay? And so let's look and see how the court handles this. So the consumers argue that the collector violated E8 when it updated its entries with the bureaus after the dispute with Experian happened in 2020. This is an important point here. So we see this dispute actually wasn't made directly to the debt collector, but it was made to Experian, and then Experian notified the debt collector about this dispute. And let's see what this footnote says. The FDCPA has a 1-year statute of limitation, and the debt collector's communication with the bureaus after disputed the debt in January 2020 is the only communication that the consumer shows falls within the applicable statute of limitation. So, in other words, those previous disputes that we talked about back in like 2017, 2019, those were too late, okay? So let's see what happens here. So the debt collector's records show it received his dispute January 2020, and that would be from Experian through the communication system, which is called eOscar. And I'll try and remember to have a link to the video where we talk about eOscar and ACDVs and all this type of stuff. How does this dispute process work when you go through the bureaus? And so they say, well, we got it on January 2020, and we responded February 3, which is in the time period for them to respond. Then they say 5 days later, we updated our reporting on the consumer's TransUnion credit report. Okay. Now, part of that is sometimes when you dispute through one bureau, the response will go out to all the bureaus. Okay, so they say the entry does not include a notation that Andrew disputed the debt the month before. And they point to this lack of dispute notation as evidence that the debt collector did not tell TransUnion that the consumer disputed the debt. So how does the debt collector respond to this? Well, they say, in here, let me get rid of that. They say, look, here's our vice president of operation. This is an affidavit. After the consumer disputed the debt, we marked it as disputed. And there was an employee who did this. And so your credit report from TransUnion is irrelevant because we have actual evidence that we did mark it as disputed. And the court says, well, there's an interesting case from Florida that said there's a genuine dispute of material fact. Now that has special meaning in what's called summary judgment. Summary judgment is where the debt collector is trying to get the case thrown out, trying to summarily get judgment against you so there's no trial. But if there's a genuine dispute of material fact, in other words, something important, and whether or not this was marked as disputed is like the most important thing. And a genuine dispute is something where a jury could look at it and say, well, we could rule this way or we could rule that way. Well, then you have to go to trial. And so this is the Sanchez case from Southern District of Florida in 2018. And there the court found declaration from the defendant's president that his company reported the disputed status of the debt to the CRAs conflicted with credit reports that included no notation. And the court reasoned the plaintiff did not have to authenticate the credit reports at the summary judgment stage. In other words, you don't have to necessarily go take the deposition of the credit bureaus to say, yes, this is actually my credit reports or my consumer disclosures. And Judge Mays says, I agree. And so here's what the 11th Circuit has said. And by the way, the 11th Circuit is our appellate court over Alabama, Georgia, Florida in terms of federal courts. So it says, otherwise admissible evidence may be submitted in inadmissible form at the summary judgment stage, though at trial you have to submit it in admissible form. So here's what Judge Mays says to sort of bring all this to an end. A reasonable juror could find that the failure to note the consumer's dispute on TransUnion report means that they did not report the dispute, or a reasonable juror could believe the debt collector. So they could go either way. That means there's a genuine dispute of material fact about whether NCS reported the dispute. So the court will deny both parties' motions for summary judgment on the E8 claim. So the plaintiff actually moved, the consumer moved for summary judgment, basically saying, look at my credit reports. They don't show dispute. And the debt collector says, well, look at our sworn testimony. It says we did mark it as disputed. And so kind of think in a car wreck case. You and I are in a car wreck case. I claim to have the green light. You claim to have the green light. Well, we need a jury to figure that out. They might believe me. They might believe you. So summary judgment would be inappropriate. Let's see what this footnote says here. So in response to the motion for summary judgment, the debt collector contends it can prevail on a bona fide error defense. Okay, so bona fide error is where a debt collector says, okay, I broke the law. I broke the FDCPA. But I have all these elaborate procedures in place to make sure that doesn't happen, and somehow it still happened. So if they can prove that, it's difficult to prove, then they can escape liability. And the court says, well, you didn't move for summary judgment on your bona fide error defense, and so I'm not going to address it, and hey, you're free to bring it up at trial. Okay, so this decision talks some about what's called a legal dispute versus a factual dispute in the context of the FCRA. We're not getting into that here. We just wanted to zero in on that dispute because part of the purpose of, I think, and this is the way I teach it, any letter to a debt collector, unless you're paying them, and even then you could still do it, is to let that debt collector know that you dispute this debt. And if you let that debt collector know that you dispute the debt, and then they update it with the credit bureaus, it must be updated as being marked as in dispute or consumer disputes. If they don't do that, that violates the section E8 that we looked at. Now, there are other types of, quote, dispute letters that you can send. There's a type where you request information. Sometimes this is called a validation and verification letter. Because those terms, people have sort of overly complicated them, I'm just going to start using sort of a more descriptive term, which is you're requesting information from the debt collector. Hey, give me a copy of the contract, monthly statements, etc. And then there's a form of letter where you say, I refuse to pay you, which means don't ever contact me again. Okay? And so we'll cover those three types of letters in our free webinar this Thursday at 11 a.m. And if you happen to be watching this video after it, you should be able to still go to the link that I have and click on that, and that'll at least get in touch with me, and I can send you a replay and all the tools that we'll provide in there. So just check out the description and the comment. You'll see the direct link to the webinar, totally free. You don't have to download anything. Just make sure you check the button for we have permission to market to you, so we can send automated emails to you about other webinars that we'll be having. Because for most weeks, we'll be having a free webinar, usually on Thursdays, unless I'm in court. And so to be able to notify you about those, we need to have that ability to communicate with you. Okay, guys, thanks for watching this, and you guys have a fabulous day. Talk to you soon. Bye-bye.